Hi guys, here's the usual disclaimer. Not a lawyer or an insider, this is commentary based on public information. Min Heejin appeared in court to testify in the damages lawsuit filed by ADOR against Dolphin Films director Shin Wooseok. In August 2024, he uploaded a director's cut version of the New Jeans ETA music video on the Dolphin Films YouTube channel. ADOR claims this release was unauthorized and questioned what right he had to post company-owned content to his channel. Director Shin subsequently deleted the music video, but he also removed all of the content from another unofficial fandom channel he operated called Min Heejin. Director Shin then filed a criminal complaint against ADOR for defamation, prompting the company to file a damages lawsuit against Dolphin Films for the upload of the music video. Min Heejin testifies that posting the director's cut separately was verbally agreed upon during her tenure as CEO of ADOR. She also highlights that verbal agreements are standard in the creative industry, and music video directors often post completed works to their own social media pages. ADOR's side responds, citing the New Jeans contract validity case verdict that dismissed the dispute with Dolphin Films as valid grounds for termination. They ask Min Heejin if she's aware of this ruling, to which she simply responds, yes. When asked about the ruling's acknowledgement of her efforts to attack HYBE with lawsuits and negative opinion campaigns, she dismissed the question as irrelevant to the trial at hand. Verbal agreements actually are legally binding in Korea, but they require substantive evidence and are often rejected if one side refutes. Min Heejin played it smart by deflecting away from the New Jeans ruling, but I think I see where ADOR was going with that. They want to paint director Shin as a bad faith actor who orchestrated the dispute to generate bad publicity toward the company. The problem is, I don't think they have Kakao messages to back it up this time, and he's not going to readily admit to it, even if it is true. So, without solid evidence, this angle is very unlikely to stick and might even come off as paranoid to the court. ADOR raised more suspicions regarding Min Heejin's dealings with director Shin. 25% of his company's revenue is attributed to his production work for New Jeans, totaling 4 music videos. Dolphin Films had an operating profit of just around 700 million won in 2021, but under a stock purchase agreement with Kakao Entertainment, it needed to achieve cumulative operating profits of 18 billion won by 2026. ADOR questions whether Min Heejin awarded director Shin with excessive work at a high unit price to help his company meet target profits. Although she confirms having received a copy of it, she denies having intimate knowledge of Dolphin Films' agreement with Kakao, insisting she had simply passed the document along to her deputy CEO at the time. I was very surprised to see ADOR bring this up. Many of you in the comments have mentioned this agreement with Kakao, and there's plenty of theories surrounding their involvement in this entire fiasco. Honestly, I see them as mostly conspiracy, but then again, I'm not familiar at all with Kakao and their history. For ADOR to openly float this idea in court was a bold move and could spark a whole host of new controversies. As the article points out, agreements like this typically carry a confidentiality clause, so director Shin sharing it with a third party like this could potentially be very problematic. Moving on, we had the 4th hearing for the damages lawsuit filed by BeLift Labs against Min Heejin. The issue stems from alleged plagiarism between New Jeans and ILIT, which the company denies. BeLift accuses Min Heejin of deploying the industry's most feared tactic, damaging an artist's reputation. They claim she premeditated these attacks on ILIT during their rookie era, with chart manipulation accusations planned as early as February. They even accuse her of showing a maliciously edited version of ILIT's debut teaser to a financial analyst to provoke a negative report about the group. BeLift believes Min Heejin chose them as a target because ILIT was newly debuted and had not yet established a strong fan base. They say she was motivated by personal gain, hoping to push HYBE into a corner and acquire their 80% stake in ADOR at a discount. She was advised by the company's law firm not to pursue these plagiarism allegations as they would be difficult to prove legally, but she exploited the angle anyway for a media campaign. Min Heejin is then said to have mobilized ADOR's staff, ordering them to monitor hype idols and even competitor idols for New Jeans plagiarism. To BeLift, this is a reflection of her true mindset that all fourth-generation groups are copying her. They then brought up Min Heejin's new independent agency to cite comparisons between the thumbprint logo and that of a Canadian craft brand called One of a Kind. To BeLift, these similarities are less coincidental than the ones between Illit and New Jeans. They insist that similarities in girl group concepts are natural given the limited themes, and highlight such comparisons between New Jeans and a Japanese girl group. Min Heejin's side counters, accusing BeLift of distorting the essence of the trial by discussing copyright-related issues. This case is about defamation and obstruction of business, they said, while noting that plagiarism was only briefly mentioned during Min Heejin's 2-hour press conference. Okay, so the oak thumbprint logo is definitely similar to that Canadian brand, but this is more of a trademark thing. Typically, when you trademark something, you trademark it within the industry that you plan to use it in. It's not really a blanket overreaching thing. Oak Toronto doesn't really seem to be in the entertainment sphere, but that doesn't automatically mean Min Heejin's logo wouldn't cause confusion in the market. Copyright law is pretty interesting to me. It's something I studied a lot in business school, but it doesn't really apply to this case. Let me know if you guys want a separate video on that, but I won't bore you guys to tears any further. As for the smear campaign stuff, it does line up with the cacao messages we've seen so far. It also lines up with the ADOR New Jeans contract validity ruling, which states that Min Heejin engaged in media warfare against Hybe and raised plagiarism issues to attack the company. So yeah, her legal team will have to work overtime to dig themselves out of this hole. Min Heejin's side argues that the use of terms like copying and plagiarism were a reflection of public opinion, not falsehoods. They claim these criticisms arose due to Illit using choreography clearly identical to New Jeans, thus damaging her group's image. As CEO of ADOR, Min Heejin had a duty to protect New Jeans, so she made these remarks in their defense. Her side accuses BeLift of projecting malicious intent onto her private cacao messages to hurt her reputation. Min Heejin clarifies that the cited conversations were internal reviews on public response following Illit's debut, not evidence of a planned attack. Isn't this literally what Hybe's leaked document was, though? Internal reviews of public opinion compiled into a report? I've seen it said that this is a common practice in the K-pop industry, and maybe it is. The content of these reports can be quite jarring and damaging to artists if publicized, which is why they are meant to remain internal. Her explanation is plausible on the surface, but still stands in direct opposition to what the ADOR New Jeans Court ruling stated. BeLift goes on to clarify the damages suffered by Illit following Min Heejin's press conference. Album production was halted due to plummeting sales, photo shoots and ad campaigns were cancelled, all while the members were subjected to relentless online abuse. This left them asking, what did we do to deserve this? Min Heejin's side rejects the framing of these outcomes as damages, calling them vague and speculative expectations. Public opinion had already turned prior to her public comments, with keywords like copying and plagiarism appearing in search trends as early as March. Finally, the court asks whether Min Heejin's press conference was a strategic move to seize control of ADOR. BeLift says they can't confirm a takeover plan, but the intention to manipulate public opinion is evident. The court followed up, asking whether such damage to their group would really justify Hybe surrendering their 80% stake in ADOR. BeLift responds, stating that plagiarism allegations can lead to severe fallout, which Min Heejin likely used to gain negotiating power. The court concluded the hearing and scheduled the next one for January 9th. The court has asked BeLift Lab to clarify damages a few times, and Min Heejin's legal team wisely picked up on that. So I think they'll continue trying to discredit that part of their argument to procedurally weaken BeLift's case. Things like plummeting sales, cancelled shoots, and online harassment are being written off as vague and speculative expectations. In layman terms, they're basically saying it's not Min Heejin's fault if people don't want to buy Illit's album, if brands don't want to work with them, and if the public doesn't like them. Just because you expected a different outcome doesn't mean it's her fault that didn't come to fruition. The problem with this argument is that BeLift is drawing a direct before and after correlation between her public statement and the changes that followed. The court asks whether the press conference was a strategic move from Min Heejin to seize ADOR because BeLift needs to prove malicious intent. Her saying she had an obligation as CEO of ADOR to speak out and protect New Jeans is plausible, but severely weakened by past rulings that say she acted in bad faith. This creates an opening for BeLift to suggest an alternative reasoning that's more self-serving and malicious. So the court is basically trying to probe that out of them. The same can be said for the Shin Wooseok case, because ADOR basically accused her of showing favoritism toward him. That's not exactly a crime. They'll need to prove this favoritism was self-serving or hurtful to the company. They brought up the New Jeans ADOR case ruling, which found Shin Wooseok's capabilities were not particularly remarkable or irreplaceable. My guess is they're trying to argue that favoring him with so many work assignments puts ADOR and New Jeans at some kind of disadvantage. Again, I don't know if that's going to stick, but it's clear that both legal teams understood the assignment here. Last but certainly not least, Dispatch has revealed the court's ruling in the Min Heejin Labour Board fine dispute. When they first reported on the case's outcome, a mysterious legal representative contacted them to insist that she had actually secured a partial win, then threatened legal action if the article was not updated to reflect this. Dispatch attempted to contact the alleged law firm they were said to represent, but they could not confirm the individual's identity or the authenticity of their threat. For some quick backstory, Min Heejin filed an objection with the Seoul Western District Court after the Labour Board imposed a fine on her for workplace bullying. The court ultimately dismissed the objection and upheld the fine, but they excluded 2 out of 4 of the allegations due to insufficient evidence. To Min Heejin, this should be considered a partial win, but it doesn't exactly work that way. The court acknowledged that she made demeaning remarks toward a former ADOR employee while serving as CEO of the agency, which constitutes workplace bullying under the Labour Standards Act. Workplace bullying is not measured in percentages. It either happened or it didn't happen, and in this case, the court acknowledges that it happened. I'm with Dispatch on this one, sorry, not sorry. Saying I only half bullied you is like saying I'm only half pregnant. Girl, what? You can't be semi-pregnant, you either are or you aren't. So yeah, I don't see how anything about this ruling is a victory, but whatever helps her sleep at night. The ruling actually lists specific expressions used in Kakao chat messages which led to their decision. The chat evidence shows Min Heejin belittling the employee with phrases like idiot, pathetic, and even referring to the employee as slow. Min Heejin argues she simply used familiar language to guide the employee's attitude, but the court outright rejects the notion of these being friendly expressions. Min Heejin, once again, objects to the ruling and will push to appeal it in a formal trial. The origin of this dispute dates back last year to a complaint filed by the employee against her for workplace bullying and attempts to cover up an incident of sexual harassment. The Labour Board recognised the workplace bullying claims and determined that Min Heejin failed to conduct an objective investigation as CEO of ADOR. Thus, a preliminary fine notice was issued. This news isn't exactly new, but I guess Dispatch wanted to combat public narratives about them misrepresenting the objection outcome. The defamation case between Min Heejin and the employee is on hold currently until the final outcome of this case. I guess we'll see how this plays out from now on. I plan to upload this on Thanksgiving, so happy Thanksgiving to my American viewers. I'm thankful for all my viewers regardless of location, and it's been a fun ride. Bumpy as well, very bumpy, but fun nonetheless. I'm aware that Min Heejin is set to testify in court today, but I'll have a video on that sometime next week after my holiday break. Please be with your loved ones today as well. I'll see you all in the next one.